All right, everyone may be seated. Please let the record reflect that the jury's left the courtroom. Mr. Dreiser.
Your Honor.
Oh, Mr. Hill, sorry.
Good afternoon. Your Honor, on behalf of Mr. Fernandez, number one, we would renew all previously filed motions with no additional argument to those motions, but this time we would be making motions to count 1 and count 2 for a judgment of acquittal. And if I may, I'll take a few minutes with these. As the court is well aware, judgment of acquittal is pursuant to Rule 3.380. If the close of the evidence for the state or at the close of all evidence in the case, the court is of the opinion that the evidence is insufficient to warrant a conviction, it may, on the motion of the prosecution or the defendant, enter a judgment of acquittal. And as the the court is well aware, that standard changed in 2020 pursuant to Bush v. State 295, Southern 3rd, 179, out of the Florida Supreme Court. Whether the state presented competent, substantial evidence from which a rational trier of fact could find the existence of the elements of the crime beyond a reasonable doubt, viewing the evidence in the light most favorable to the state. So I want to start with count 2, the solicitation, Your Honor. The state is required to prove the defendant commanded, encouraged, hired, or requested another person, in this case, Henry Tenen, specifically from November 1st of 2021 to February 16th of 2022, requested Henry Tenen with the present intent that the other person actually carry out the offense. As the state has in their case, it's not necessary for the defendant, Mr. Fernandez, to do anything in furtherance of the offense. However, to solicit means to ask earnestly or to induce another person to engage in that contact. So the definition of earnestly means a serious manner, not lightly, casually, or flippantly. The statute requires, there is no affirmative defense that we have alleged. However, it does require an affirmative communicative act, a command, encouragement, hiring, or request directed at another person. I would point out that the state has not submitted any evidence to the jury of that affirmative communicative act. There's been no testimony that Mr. Fernandez has said a word of encouragement, a text message, an email, or any other act that would actually support that he solicited Henry Tenen. And I'd point to several different cases that specifically are on point, which is in order to show the present intent, and that would be the Florida Bar versus Marable, 645 Southern 2nd, 438.
Slow down. 645 Southern 2nd.
Yep, and I'm going to email those cases to you at this moment, Your Honor, as well as to the state. In that sense, so you'll have an electronic copy of all case law. Bear with me, Your Honor, I'll give you that exact citation. That was 645 Southern 2nd, 438, 1994. And it was Marable, M-A-R-A-B-L-E, which establishes that present intent is required, meaning that Mr. Fernandez would have to have the present intent in addition to the solicitation and the communicative act in order to be found guilty and sustain a conviction for solicitation to commit a capital felony. In addition, Palumco, P-U-M-B-L-A-N-C-O, v. State, which is 111 Southern 3rd, 249 out of the 5th DCA, and that was 2013. In addition, State v. Gaines, 431 Southern 2nd, 736, 4th DCA, 1983. That actually established what's considered the Gaines standard. In order to support, there has to be a present intent. In that case, a particular person, their conviction was overturned when they expressed a desire for this to happen in the future, but they did not actually formalize that solicitation. And the court found that that person did not have the present intent for the crime to actually have occurred. Additionally, Your Honor, Jones v. State, 908 Southern 2nd, 615 out of the 4th DCA, which is 2005, requires guilty knowledge or mens rea on behalf of the defendant. I would just point out that there's been no witness who has testified, number one, of any evidence of the actual earnestly requested solicitation by Mr. Fernandez to Henry Tennant during the time period alleged, and simply having that relationship in and of itself with Mr. Tennant is found to be insufficient to sustain that conviction. There's no evidence of encouragement. There's no evidence that Mario Fernandez hired Henry Tennant to commit this homicide. Even in the light most favorable to the state, the checks that have been presented by way of Detective Johns and Miss Lindsay Butler are post the time period of which the state has charged Mr. Fernandez. There's been no testimony that those were actually for the homicide. There's been evidence submitted that Mr. Tennant completed legitimate work by way of the recorded phone call and the poll cameras that are in evidence as well. Additionally, with regards to count one, as a principle, murder in the first degree, there again has been no evidence of the intent. There has to be a communicative act to show that Mr. Fernandez had an intent for this crime to occur. Having a not positive relationship, if the state were to rely on the interview of Mr. Fernandez, where he clearly states that him and Mr. Bridegan didn't have the best relationship, that in and of itself is not sufficient evidence to submit to the jury that Mr. Fernandez had the intent that Jared Bridegan be murdered. Additionally, the second element, as a principle, that the defendant did some act or said something, again, a communicative act, or did some act that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. There has been no evidence at all to establish Mr. Fernandez's intent. Nothing to be submitted to this jury, either for the solicitation or for the murder in first degree as a principle. As the state conceded, Henry Tennant is who they believe to have actually committed the homicide, not Mr. Fernandez. That is why they have submitted the principal instruction. Again, simply having that relationship with Mr. Tennant does not carry the day. With regards to element two, we have heard no evidence of any incitement, cause, encourage, assist, or advise the other person to actually commit the crime. And I would draw the court's attention to a case that's so close to being on point. It's in essence a man killing the husband of the woman he was having an affair, and that's Williams v. State, 314 Southern 3rd, 775. That is a first DCA case from 2021. That proof of a relationship alone with the perpetrator is not enough. There must be proof of some overt act or words uttered in furtherance of the scheme that led to the murder, and where no such evidence exists, a motion for judgment of acquittal must be granted. Under Penny v. State, which is 421 Southern 3rd, 476, out of the second DCA of 2025, in order to be a principal in a crime, one must have a conscious intent that the crime be done and do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The one other point I would establish is that Coxwell v. State, 397 Southern 2nd, 335, 1981, establishes that both the principle for first-degree murder and solicitation both require the same communicative act in order to establish the intent, as well as with count two, the actual solicitation. This means that solicitation charges and the principal liability charge both require the same proof of the communicative act. The act of counsel, procurement, or instigation. Where the state has submitted no evidence of that act, both charges fail simultaneously. The absence of any evidence of the communicative act, therefore, is fatal to both the solicitation charge as well as the principal liability charge. There's been no evidence submitted. I would argue contrary evidence that Mr. Fernandez had any motive to commit this crime, much less any intent that was submitted into evidence. There has been no testimony whatsoever to establish the intent element. Certainly no evidence of communications that support the intent or an overt act. and mere association with or proximity to the perpetrator is insufficient to establish principle. Applies to both murder as well as, by principle and solicitation. In every Florida case, a solicitation conviction has been sustained. There has been some form of evidence of the communicative act. I draw the court's attention to Castro v. State, 939 Southern 2nd, 306, 4th DCA 2006, where an ex-husband sought to have the ex-wife murdered by a hitman. The defendant communicated with an undercover FBI agent, recorded conversations, communicating desire and intent to have the ex-wife killed. Robinson v. State, 267 Southern 3rd, 567 1st DCA 2019. Defendant clearly and repeatedly expressed present intent to commit first-degree murder. Hudson v. State, 368 Southern 3rd, 70 1st DCA 2019. Jail phone recordings providing victim's address to gang members and relief the victim had died. Those three cases are where the convictions had been sustained because of the communicative act that was recorded or ultimately testified to.
I might be familiar with the Hudson case.
That might have been your case. I didn't see that in the footnote. You won't have to read that one, I suppose.
Okay.
By contrast, there has been no evidence of any communicative act by the defendant to Henry Tennant, who is charged in this case as far as the solicitation. There has been no evidence that Mr. Fernandez asked earnestly as required by the statute. No competent substantial evidence. Maybe evidence that the defendant learned after the murder, but no evidence of prior knowledge or conscious intent. And one further argument, Your Honor, is that the state is prevented from inference stacking. The state is seeking to simply stack inferences and may get up and argue that this is somehow putting pieces of a puzzle together by way of circumstantial evidence. However, the Florida Supreme Court ruled in Baugh v. State, 961 Southern 2nd, 198 in 2007, its well-established evidentiary principle bars a criminal conviction when the fact finder must draw an inference from another inference rather than from admitted evidence, and it remains in place even after the JOA standard was changed by Bush v. State. This is not assembling pieces of a puzzle via circumstantial evidence, Your Honor. Based upon that argument in the case law, we would move for a judgment of acquittal on count 1 and count 2.
Okay. Can you give me just a moment? I'm trying to catch up. Did you send that?
I sent it to you.
You sent it to my judicial assistant?
I did, Your Honor.
Can you send it to me?
I can.
Thanks. The Williams case, that's the duck hunting case.
It is, Your Honor. Your Honor, admittedly, I don't have your email address, but your JA just indicated she received it.
Okay.
I'll ask her.
Well, I don't know. Well, she'll send it then. Thank you. Okay, I'm ready to hear from the state.
Yes, Your Honor, I appreciate the defense counsel bringing up the new standard in Bush, because they spent the vast majority of their argument speaking about direct evidence that's required to prove a particular crime. Obviously, the state has put forth a substantial amount of circumstantial evidence that proves this defendant is guilty of both charges. It begins with 1,000 different facts that distinguish it from the Williams case, including that the Williams case specifically had a co-defendant that specifically provided testimony, essentially exculpating the defendant by saying, well, she didn't really help me plan the murder. We did talk about it, but I did it on my own. In this particular case, the only link between the stipulated shooter and the victim is this defendant. It's his tenant. This defendant had a motive that we've spent a lot of time putting forth evidence of This defendant had access to the 10-millimeter firearm that was eventually potentially used in this case. This defendant had a consciousness of guilt after the fact by deleting text messages and resetting his phone so things could not be discovered. This defendant's tenant went on a dry run all the way to the victim's home, all the way to the crime scene, and then back to the rental home where this defendant was. This defendant paid the stipulated shooter for what a reasonable juror could believe was payment for the homicide. Again, doesn't require specific direct evidence of the payment, merely that a rational finder of fact could find that that was paid for the homicide in context of all the payments made to all his different business ventures and those phone records, and those financial records. The outlier of Henry Tennant's $10,000 is stark and shocking, and a reasonable trier of fact could see that that was payment for the homicide. So in the totality of all the evidence, it's very distinguishable from Williams. There is competent, substantial evidence in multiple different arenas that this defendant was the link, the hub of all the spokes that ended up with this victim dead. And if the court has any specific questions or any specific things we need to talk about, I can certainly answer those questions, but I think there is competent, substantial evidence. And I'll point out that the solicitation in all those cases, the act itself didn't happen. You're just talking about it to an undercover police officer, so you have the solicitation going on. Here, the act happened, so you don't have to worry about whether or not there was an earnest ask, since the earnest ask ended up in the victim's murder.
So the defense points out that there's a lack of evidence related to, even viewing the evidence in the light most favorable to the state, of any communication for the solicitation.
Sure.
I can go down the elements, but...
Well, the communication, certainly the evidence is that he paid for it. But in addition, Your Honor, this defendant had substantial contact with the tenant in the months and days leading up to this crime and after the crime. Those contacts were deleted by both parties on their phones. There is no requirement in the law that we use one co-defendant against another co-defendant as long as there's substantial competent evidence to show that the agreement happened. Your Honor knows the agreement happened, the solicitation happened, because the victim was killed by his tenant with no link to the victim. So remember, the solicitation in a lot of those cases about the communication has to deal with situations where the ultimate act did not occur.
Okay, so I'm going back to the elements. It's commanded, comma, encouraged, comma, hired, comma, or requested.
Right.
And then...
And the only reasonable, in the state's mind, in the light most favorable to us, which is what the standard is, the only way to view the evidence that we've presented is this defendant hired Henry Tennant to do this.
Okay. Well, give me just a second. So that Williams case is a little dense. They go through a lot of
It's really dense. And it took me,
legislative history, but really what it comes down to, where the first district found that the trial court erred, is that, like Mr. Mizrahi pointed out, there wasn't any, well, actually the flip co-defendant flipped back and said that there was basically, this person, Denise, did not do anything. Additionally, there was talk prior to, which they found the trial court did not err in not, well, basically letting the case go to the jury on the conspiracy, just the other two crimes.
Your Honor, I would just point out that the Williams case was specific to the principal theory.
Of first-degree murder?
Correct.
Correct.
And I didn't know if you were speaking to
No.
the...
So there were a lot of things at play. There was conspiracy. There was first-degree murder. The principal theory, it was related to that because they were saying assist, advise, encourage, and they were going through the legislative history of the words aid and abet, and they were going through, that's the part that's dense a little bit. But ultimately, if you get to the meat of the opinion where trial courts need to be aware is that, let me go back up. So in that case, which Mr. Mizrahi points out, it says while, and I'm reading, let me see what page is this, 787. It says, while Brian characterized the planning of the murder as very mutual, he also stated that he planned a lot of it and that he instigated a lot of it. And Brian never testified about anything Denise did or said to incite or encourage him to commit the murder. It's very different, I guess, factually, which is what Mr. Mizrahi was pointing out, that you had someone that was at one degree/level, and I think that's where the appellate court was drawing the line, saying that Denise Williams was culpable, her conduct was culpable based on words when it related to the conspiracy, but not because of this Brian witness. He delineated that he was the main factor, therefore making the evidence not competent or substantial enough to go to the jury. That is the way that I read that. So in this case, while I hear the defense say, and your theories are based on all of the cross-examination that you did, the state of Florida is allowed, if legally sufficient, to go to the jury based on the evidence. And I am familiar with the inference stacking, but there has to also be basically, the court has to be careful between that prohibition by law and what is legally permissible related to circumstantial evidence. And so I believe that the evidence that this court has seen through the testimony of the witnesses, viewed in the light most favorable to the non-moving party, which is the state, is sufficient to go forward. So I'll deny the motion for judgment of acquittal.
Was that to both,
on both counts? On both counts.
Understood.
So let's have a conversation about what's going to go on tomorrow. You're going to have your witnesses available and ready at 9 a.m., if any?
Yes, Your Honor.
Then what?
I would expect it to be an extremely light day. I think you've given me latitude that if that happens, we can work on our closes and close Wednesday.
Yes. So what I would like to do is, depending on the hour and time, we will finish the defense case. Is there anything left unmoved in, or everything's in from your perspective?
Everything's in from our perspective at this point.
Okay. We will do that. We will have the charge conference, as I've previously indicated. Melanie, I'm going to ask that you stay, okay? I'm going to talk to the lawyers off the record, but I'm going to ask that you stay through that conference off of the record so that we can put it on, so that starting hopefully Wednesday at 9 a.m., I would read a portion of the jury instructions up until the point, and this is where I stop. I don't know that you all have tried anything with me, Mr. Dreiser, Mr. Hill, Ms. Day. So what I do is I read up until submitting the case to jury. Oh, no, I'm sorry, rules of deliberation. So I stop there, and then I don't read rules for deliberation. I stop right before then. I let y'all argue. Then I pick up after that, submitting the case to jury, the verdict forms, and then they would retire after that for their deliberations. Does that sound okay?
Yes, ma'am.
And does the court envision not doing that Wednesday afternoon or waiting until Thursday morning? I guess since we have a waiver, it doesn't matter.
Well, I would let them deliberate late. I mean, late, like 8, 9 o'clock, and then let them come back if they can't reach a verdict. So if we start at 9, these jury instructions aren't that long. So I would envision that they would possibly get the case early afternoon. So they would have 6, 7 hours to start deliberating.
And is there any chance of doing the closing tomorrow, even if it's a bifurcated
No.
proceeding? Okay.
I wouldn't do that. What I would do, I will give y'all, so what we would do the charge conference, we break so that you all have plenty of time, you're rested, the jury's rested, so that you all can work on your closings, you'll know what the law is. That would be my plan.
Yeah, just hashing it out really informally with the state, it's probably going to be like states close in the morning, defense close in the afternoon, and then deliberation, given the time that each party thinks they'll go.
I read about a minute or so a page, and so the opening instructions are about 20 pages, so that's like 20 minutes, give or take. And then, so you think your closing would be
Say she does
all morning?
Well, if she does, let's just say she goes a couple hours, then I would
Need a
probably
break.
request that they get maybe an early lunch, and then I go. Maybe we just,
Lunch is like a clockwork, Mr. Dreiser, so it comes at like 11.
I would tell the court probably an hour 30 to hour 45, but build in a little extra time for that,
so,
just in case.
So for your first close?
Yes, ma'am.
and then if I'm long, so just,
Okay.
so I would still want to, that I would like to not be broken up. Like I don't want to, and then take a lunch.
Would y'all rather than just come back the next day and deliberate?
I think it depends. Let's say we take a lunch.
I'm trying to give them a whole day. I could start the instructions at 8:30 if that would help.
Can we discuss amongst ourselves and come back to the court with some kind of better idea of scheduling? Now that I'm hearing this, I'll speak to Mr. Dreiser about how many witnesses tomorrow. It's conceivable, rather than breaking it up that way, I could get through first close tomorrow afternoon, depending, but I need some time.
I think that's a really strong possibility.
So let me propose this so for your discussions. You don't have to commit. Let's say the defense finishes relatively early. We have our charge conference. I don't think it's very complicated. It's very straightforward. There are a couple of things that I'd like to talk to you all about tonight that I think would help. Would you like for me to read the instructions, send them home, and then start your closings in the morning, first thing? And then would that help? So in the morning, if they start at 9, they essentially have 4 hours. And then, do you think you could get it done by then?
I think we would have the entire afternoon.
Right.
As much as I like to give it didn't have been rested, it seems silly to waste that time from the state's perspective. I think that the thing that makes the most sense is that we do the defense case, we have a charge conference, we have a large break for lunch. The Stifler does her closing, we come back fresh on Wednesday for Mr. Dreiser's closing in the bundle. Then they get their case much earlier in the day.
When would I be reading, according to your plan?
Before Ms. Stifler does her closing.
So 20 minutes, you would, okay.
I think we would have the whole afternoon.
I think he may be right.
Right, that'll give us 4 hours, and that's plenty of time to get the instructions and first close done tomorrow afternoon.
And then it'll be the next day, defense close rebuttal case.
Mr. Dreiser gets a overnight to think about it, so
They get a nurse to his minute.
it,
I'll take it.
You're also giving him extra time to like figure out what to say.
yeah.
Longer and longer.
God, I probably couldn't do it without that extra time, but thank you. I'll take it.
I'm joking. All right. Okay. First order. All right. We'll be done for the day then. And I want to see the lawyers at sidebar because I have a few questions that will help me. I'm going to push my draft of the jury instructions out to you all. Okay. No, I just have some questions before all right, court's adjourned. Thank you.